All rise. Court of Appeals Division 1 is now in session.
Please be seated. And we'll take care of some housekeeping first. Our colleague Judge Thompson has been unavoidably detained. He was on his way back from Colorado, but his plane would not take off. So he will listen to the argument. He's talked about the case with us, so he will participate. Our first case today is one CV140525 is Glass versus Classes. We have read the briefs and we've conferenced the case. We're fully aware of everything. We will be doing audio tape the argument today, so you'll be YouTube stars in a couple of days. Each side will have 20 minutes for argument upon it. You can reserve any amount of time that you want for a rebuttal, but you'll have to keep track of the time yourself. Because we are recording the argument, when you begin, please identify yourself and your client. Counselor, you may begin.
My name is Joseph Charles. I represent the Glass and Garden Church. Thank you for this unique privilege and honor. I am deeply humbled to be in front of you. Pastor Gene James was the pastor of this church. He sent a memorandum or communications to a group called the Classes on September 26, 2013. He entitled that, "This is Wrong." That's in your record before you as part of the appendix as Exhibit B to the motion to dismiss. I will demonstrate this morning to you why Pastor James authored that memorandum to you.
Well, Counsel, let's talk about what we're dealing with here. As I understand it, and correct me if I'm wrong or if the record says otherwise, but the consistory of the Glass and Garden Church asked the Classes for a supersession, and the Classes met and consulted with the representatives of the consistory, and the Classes took control of the church. If that's what happened, then why should any court get involved in church governance?
And I will tell you that. I will explain that as you allow me to go forward with this, Your Honor, with all due respect. Judge Gamma, a very good trial judge, classmate of mine, issued the opinion in this matter. And in the assessment, in the first assessment that he quotes from that, he states in his opinion, "This is a case involving the dissolution of a divided religious congregation." That conclusion, that legal conclusion, was wrong, Your Honors. But let me briefly review why. Pastor James was the pastor of a local congregation. That congregation was under a denomination, the RCA, the Reformed Church of America. The Classes is a voluntary group of pastors and elders that voluntarily have a committee, and they come in and do certain functions under the denomination umbrella.
Well, Council, as I understand it, though, the church is hierarchical, so the classis is a superior body to the consistory.
That would be generally correct, Your Honor, when appropriate. Now, what
Well,
Pastor...
and who determines when it's appropriate?
Well, that's going to be followed by the Book of Church Order, and that's what I'm about to get to with you. Because Pastor James, in roughly the June of 2013, sought, and he was part of the classes, by the way, he was part of that committee, and he was told and believed that he could go to the denomination and borrow some monies. They needed about $25,000 for some reason within the church. Most churches and businesses in 2013 were suffering to some degree. We were in a recession still. He couldn't go to a bank, and he was told to invoke the justice. So the treasurer and secretary of the church wrote the letter that you're talking about. Under the Book of Order, then under the article there are 10 factors of which the classes will come in. 9 of those 10s have to do with a dysfunctional church. This was not a dysfunctional church. It was an operating church. The last one, the 10th point, is if the consistory requests supersession. Dr. James, he was a doctor as well as a pastor, was told that by requesting this would open the door for the books and records to be examined by the classes, and they would make the appropriate due diligence review as to whether or not a loan was going to be made. So,
Councilor, but even assuming all that is true, isn't that a matter for the church to resolve for itself? It's a matter of how that church is governed, whether the consistory controls or whether the classis does, and why should any court get involved in that?
because, Your Honor, the pastor, quite frankly, was lied to, misrepresented for the purpose of the classes coming in. Within 90 days of them coming in, they locked, in the letter that was part of your record, they had locked the doors and locked out hundreds of members of that church from worshiping there.
Well, Mr. Charles.
Yes, Your Honor.
Maybe I'm just trying to simplify this
Sure.
too much, but isn't this case a dispute about who gets to control the financial records of this institution and who gets to control the physical property owned by the church?
Only in the essence that, yes, property rights, and the Supreme Court has spoken to that the neutral principles of law do govern property rights. And the Madison decision, that is a Texas decision last year, clearly is almost on all fours on this case, opens the door that there's really only one principle of law that should be guided. That's the neutral principles of law. So in other words, if Pastor James had been misled and allowed someone to come in, because you see, the denomination didn't come in to birth a new church within their denomination. They didn't come in to put another church of their denomination there. What they did is they locked out Glass and Garden and made a lease with a total competitive church to go in there.
But
That's wrong.
I'm sorry. I mean, really, isn't the dispute here between the various levels of the church as to who gets to do what and under what circumstances?
It would, again, Your Honor, it would be if the truth of the matter was that was the natural of the conflict, but that wasn't it. As I mentioned, under the Book of Church Order, there was not a dispute within the church. There was an alienation of relationships within the church. They simply went to the denomination, or I may call it that, or classes, to seek $25,000 of financial help. That was the only reason. Pastor James realized within a month they weren't going to help him. They alienated him and put him aside. What should have been done is just to revoke their relationship with him and consider it a fraud on the local church, because quite frankly, Your Honor, the local church was dismantled, gone, as a result of the actions of these parties.
But there seems to be a claim that the classes improperly invoke the procedures in the book of church order, and that I'm sure that there are adjudicatory procedures within the denomination to resolve whether the class has overstepped its bounds or not.
Well, Judge Howe, with all due respect, when Pastor James writes a letter saying you've locked me out, you've taken our van, you've taken our building, you've taken our land, you've taken our books, our musical equipment, we are locked out. Where were those people? And he puts in there, and we have over 100 people wanting to worship. And it says in the letter, October 1st, our church is now going to be a different church body in there, unrelated to the RCA. What was he to do? We're 2 years later showing that hasn't been the fact. It hasn't been that they helped make another RCA church that their book of church order requires or submits them to do. They've totally dismantled the church. How can that be fundamental fairness? How can that be right? And that's what the Madison decision from Texas says, that courts, when they see a wrong, can, under neutral principles of law, correct that wrong. What they've come in is taken the property that belonged to, by the way, let's talk about that issue for a second. The property was vested in an Arizona corporation. This local church was a solely owned Arizona corporation by the church members. It's a complete legal fiction for the denomination to come in and say, well, we're taking it over and we're going to have new directors and new this within it, because the members of that corporation have to be part of that church. That's a legal fiction. All of this would have been flushed out if the motion to dismiss hadn't been granted in this case. Number one, the fraud perpetrated upon the pastor. Number two, the wrongful taking of the Arizona corporation, control of it by non-members that violated corporate law. That's what Madison discussed. That's what also this court talked about when it said that neutral principles of law will be governed on membership, on employment membership, on torts, on criminal acts, or on the taking of property. This was, in fact, a taking of property. Yes, Your Honor. I see you had a question.
No, I'm just listening, Mr.
So
Charles.
this was a complete wrongful taking of property from a local Arizona corporation by the classes under the subterfuge that they were supposed to come in and help. And by the way, and I won't, you've read the Wolf decision and the Jones decision, so I won't bother you with any of those. But Judge Gama himself was to some degree, may I say, misled in regard to the argument, because Judge Gama asked counsel for this thing, does Glass and Garden Church still want to be part of the RCA? Now, this is highly important. At the oral argument in February of 2014, counsel was asked from the denomination, does Glass and Garden want to be part of the RCA? Well, in truth and in fact, the Glass and Garden didn't exist anymore. They had been locked out. The answer to Judge Gama, yes. But the answer is, will the church be reconstructed or will it be dissolved? That's what, again, Judge Gama asked, will the church be reconstructed or will it be dissolved? The answer, a decision has not been made. In truth and in fact, to Judge Gama, the answer should have been the church was locked up, Your Honor, 90 days after consistence was brought in. And here we are months later, and we've leased the property to a competing denomination. And then you'll see on page 16 of the oral argument to Judge Gama, this is the oral argument, Judge Gama acknowledged in this case, now he's talking about this case, Glass and Garden, I think the argument is from your opposition, Mr. Schaefer, that no one's leaving the RCA. That essentially this church will remain a part of this group. That understanding was wrong. Do you understand? In other words, they were asked, Judge Gama, as asking, isn't the people going to stay there going to be under the RCA, under this denomination? Isn't that what's going on? And the answer is yes, they will remain within that group. February 29th of 2014, Glass and Garden Church no longer existed as a functioning body of people. There was a competing non-related church, the RCA, in that building operating at that time.
Can I just ask this one question?
Yes, Your Honor.
And I understand what your argument is, but is it true or not true that the consistory invited the classes in to take over?
It's absolutely true that a letter was written, and at the meeting, now here's what needs to be understood, if I could. At the meeting that was held June 29th, Dr. James, Pastor James was at that meeting. He vocalized to the consistory of the classes, what was the purpose that they asked him to come in. If the court would have allowed, if the lower court would have allowed, Pastor James and his members would have said, we only asked the door to be open for a $25,000 loan. They could have said yes or no. They said no, our church keeps going. We were unified, worshiping one body. If they said yes, we would have used the money in whatever purpose. That was the sole purpose of asking their help. The only purpose.
But isn't that really the problem? Your argument is that the classes overstepped its bounds and went too far. The classes, I'm not speaking for anyone, but I'm sure the classes are going to say it operated under a proper court procedure. So how can Judge Gama, or how can we get in the middle of that? That's something not appropriate for us.
Because again, the Texas court has spoken to that, Your Honor. You can't hide behind the ecclesiastical order to do wrong. What they did is wrong. They took the property, the books, the van, everything from this church and shut this church down. Why don't you ask this gentleman, why and how did they lock the doors to a functioning church within 90 days of having to come in and help? Why did they lock the doors 90 days when they supposedly came in to help? Was that helping the Glass and Garden Church to lock the doors and lock the pastor out and lock the group out, the worshiping people out? Be a good question to answer. Thank you, Your Honor.
Counsel, are you reserving time for the? Thank you. Counsel?
Good morning, Your Honors. Bob Schaefer on behalf of the appellee, the Glass and Garden Drive-In Church, and the Classes of the Southwest Reformed Church in America. May it please the Court. Your Honors, as far as church disputes go, this one is easy to resolve. Judge Gama properly recognized that this was a church self-government dispute. And under the ad hoc committee of parishioners case, which cited and relied on the Serbian Orthodox Diocese case, the First Amendment divests the court of any authority to become involved in resolving church government disputes. The last question, Judge Howe, that you asked is exactly the right question to ask in these type of cases. There's always two sides to every story. I could stand up here and I could answer all of these questions, but these are not issues that are committed to civil courts.
Okay, what is the internal procedure under the Book of Order or the Constitution of the RCA to resolve issues like this?
Yeah, this is all laid out in the Book of Church Order. It lists the authority of the consistory to make decisions as to both the business affairs and the religious affairs of the local church. That decision can then be appealed by any member of the local church to the classes. Their decision can then be appealed to the regional synod, and that decision can be appealed to the final authority, which is the General Assembly. So what happened here is a consistory of the local Glass and Garden Church sought supersession. Mm-hmm. The consistory is not here today. The former consistory is not here today challenging the decision of the classes. One member of that former consistory has gathered together former members of the church along with himself, and he is challenging that decision. But he has not followed the Book of Church Order in terms of how that decision should be appealed. If he believed that the classes overstepped its bounds, he had a right of appeal to the regional synod. He has not exercised that right. He has come to the court and essentially, in reading trying to make sense of the papers that they filed. I think their essential argument is that the corporate governance statutes in Arizona do not permit a religious body like the classes to come in and to supersede and appoint directors of this corporation. But that argument itself was addressed by the legislature in Arizona in ARS 10-3180. The legislature said that these rules, these statutory corporate governance rules, shall apply unless the religious doctrine of the church is inconsistent with these rules. And we don't think the religious doctrine is inconsistent with the corporate statutes, but to the extent it is, the court would have to defer under the Serbian Orthodox Diocese case and under the First Amendment to the decision of the hierarchical authorities.
So with respect to these sort of internal appellate remedies, where you say that you're going to appeal to the classes, you can appeal to the regional senate, and then appeal to the General Assembly, are there time deadlines with respect to taking those actions? Are they foreclosed from those remedies?
The answer to that question is something that I can't answer because I'm not familiar with whether there are time limits or whether they would be foreclosed now. I think those decisions would have to be answered by the authority that is appealed to.
Can a former consistory or members of a former consistory use the internal appeal process? The reason I'm asking is that if the classis supersedes consistory, then the consistory goes away, and I'm a little confused about who would be able under internal procedures to challenge the classis.
Well, this is laid out in the Book of Church Order, and there's a particular provision that states that the classis shall exercise appellate supervisory power, and it also says in discussion of the consistory that any member of the consistory that was superseded can appeal any act of the classis. So this is core religious governance of this hierarchical church. And the Serbian Orthodox Diocese case made clear that there's no permissible way to distinguish between matters of religious belief and doctrine and religious government. There is a matter, this is a matter of church governance. It's a matter that's committed to the internal operation of the religious authorities, and the First Amendment compels civil courts to defer on matters of church governance. That's the part and parcel of the religious liberty protected by the First Amendment.
Well, this group of plaintiffs, as I understand it, includes a member of the former consistory, which under your statements to us would be bound to follow those internal procedures. It also consists of individuals who aren't members. Are they so bound? I mean, can't they bring their own action for some sort of civil wrong if they can allege one?
Well, that itself is a question that would be committed to the church authorities. Whether under the church laws individuals that were not members of the consistory could appeal is itself a matter of church government. And even under, I guess the question really, I think, is could individual members of this church or people claiming to be members of this church invoke secular corporate governance statutes and argue that somehow what the classis did wasn't in compliance with these secular corporate governance statutes?
So your argument really is we have to look at the subject matter
Correct.
of the claim to determine where it lies.
That's correct. That's correct. And in fact, that was the very approach taken in the ad hoc committee of parishioners case, where the court looked to the subject matter of this dispute and asked whether it was within the area of church autonomy that the First Amendment gave. Unless the court has any additional questions, I don't think any more needs to be said. The trial court, Judge Gamma, gave the right answer in this case, and we believe his decision should be affirmed.
Thank you, counsel. Counsel.
There was no religious doctrine discussed or in conflict in this in Glass and Garden Church. It was an issue of needing property, wanting property help, and the classes taking the property away. Nothing else.
Isn't that an issue of church governance, though? And not just doctrine, but church governance?
No, Your Honor. Quite frankly, it's an issue of church property rights, and that's what the Texas decision has clearly discussed, and I trust and hope that this honorable panel will read. It's a 2014 decision on all fours. And secondly, the United States Supreme Court case that gave us the right to even be in here today was the 1979 decision of Jones versus Wolf. That was the Presbyterian case in Georgia, where the denomination was trying to take the property from a local church in that case. And the same type of arguments were made in 1979. And our U.S. Supreme Court said, no, this is wrong. There are neutral principles of law that need to be addressed. When I tell you that a pastor was defrauded, fraud was perpetrated on, that should be addressed at the state court level. That's what our Arizona Constitution allows. When I say as hundreds of his people were locked out of their church of worship, that's wrong. That's a property right. Now, if I was here today and these gentlemen had put in another RCA church and our people were just upset with that, then you'd have every right to tell me to get out the door. But that's not what happened here. Don't you see what happened? They took property from an Arizona corporation church, local church, gave it to a denomination, the classes did, and they turned around and leased it to a competing church. It doesn't make any common sense. It doesn't. And so what I'm suggesting to you is at the very least, under this Texas decision and under the Arizona decision, to make a brighter light so the judges, church members, and people can see that neutral principles of law can be addressed in our court when there's a fundamental unfairness of due process rights under our Arizona Constitution. That's what this is all about. So in regard to it,
And counsel, did your clients try to pursue the internal appeals procedure under the RCA?
What our clients did is, as I started this out, Pastor James after being alienated out of the process of knowing what's going on within it, when they took over and he's locked out, says, this is wrong, this is wrong. Now, by the way, in the oral argument before Judge Gama.
Well, I'm sorry, counsel, but that doesn't answer my question. Did your clients pursue the internal appellate procedure?
There is no internal actions within this denomination. There's no such a thing like that.
So counsel's not accurate then?
I'm sorry, Your Honor.
Counsel isn't accurate in what the Book of Order says?
It's an effort in futility for them to do it. They were locked out of their property. They couldn't go in there anymore. And by the way, Judge Gama was... I'm
Charles,
sorry.
So I think the answer that I'm hearing is, yes, the Book of Order provides for appellate remedies, but your clients decided that it would be futile to try and take advantage of those remedies and therefore has not done so.
That might be an appropriate answer, Your Honor, yes. Because 90 days after seeking their help, they're locked out. And by the way, at the oral argument, Judge Gama brought up, well, there must be, this classes must be wanting to mediate the issues, and it's in the thing. And counsel rightfully said, well, I wouldn't call this a form of mediation. It's a form of supervision. And actually, I would say it was a form of taking wrongfully the property. I apologize. I can understand. I can see that I just have not been understood, and I apologize. I hope and trust the Texas decision you might take a look at and the Arizona decisions. This was a wrongful taking of property. And the Texas decision says it's just wrong to close these matters under ecclesiastical hierarchy. Those are for theological questions. Those are for religious questions. This was taking of property. That's wrong under any color of any church, government, or ownership of business. Just wrong. Thank you, Your Honors.
Thank counsel for your argument. We'll issue a decision in due course, and I think we will stand adjourned until the next argument. Thank you.